Can an officer legally demand to see your guns? That question can turn an ordinary day into a legal nightmare if you don't know what to do. And most people don't. Today we're cutting through the confusion and giving you exact, repeatable actions and phrases to use the moment you face two common, dangerous encounters: an ATF agent or cop pounding on your front door demanding to see firearms, and a traffic stop that suddenly becomes a search for weapons. This isn't theory or speculation. These confrontations happen all the time, and a single careless move, a comment, a reach, a pause, can cost you your rights or worse. You need clear, surgical guidance: what to say, what to refuse, how to protect yourself without escalating the situation. We'll walk through step-by-step scripts you can actually speak out loud, micro-actions to take immediately, and the exact words that shut down searches without handing over your rights. No fluff, no legalese you can't use under stress, just actionable steps. Start here: the knock on your front door. Picture this: a knock. You look through the peephole, and it's not a neighbor. It's an officer or an ATF agent. He announces something like, "We have records you bought multiple firearms. We need to confirm you still have them." Right away, ground yourself. This is not small talk, and it's not optional. How you respond in the first moments determines whether you keep control of the encounter or hand it to them. First, do one simple thing and stick to it. Do not open the door. Closing the door isn't rude. It's how you protect your Fourth Amendment rights. If you open even a crack, anything the officer can see in plain view becomes evidence that can justify a broader search. A gun case on the couch, a box of ammo on the table, a safe in the corner. Those can all be pointed to later as probable cause. So keep the door shut. When they speak through the door, your lines matter. Say calmly and clearly, "Officer, I am exercising my right to remain silent. I do not consent to any search." Then stop. Don't explain. Don't tell them where your guns are. Silence is a tool. The less you provide, the less they can use. If they push, repeat the phrase and don't get drawn into arguing. If the officer claims to have a warrant, you still do not open until you verify it. Tell them, "Please slide the warrant under the door so I can review it." Read it carefully, check the name, the address, the judge's signature, and most importantly the scope: what locations or items are explicitly listed. A warrant for a person or a specific drawer does not authorize an unfettered search of your whole house or your safe. If the warrant's scope doesn't match what they're trying to do, say, "I do not consent to any search outside the scope of this warrant." Keep your tone controlled. Record the time, the badge number, and any names you can see. If they present an arrest warrant for you, that's different. An arrest warrant can justify entry if they have probable cause you're inside. Still, do not volunteer information. Ask to see the warrant and remain calm. If they force entry without a warrant or exigent circumstances, your fight is in court later, not on the porch. So avoid physical confrontation and document what happened afterwards. Expect bluster. Officers sometimes say, "Do it the easy way or the hard way," or "Show me now and we won't tear your place apart." That's a coercive tactic. Don't fall for it. If they truly had probable cause to get a warrant, they would likely already have one. Repeat your refusal to consent and stay silent. The goal is to avoid creating any new justification for a search. A short, safe script to memorize. "Officer, I do not consent to any search. If you have a warrant, slide it under the door and I will review it. Otherwise, you must leave." Say it once, then stop. 2 practical safety notes first. Keep your phone accessible and start a video or audio recording only if it is safe to do so. It can be crucial later. Second, if you live with others, quietly instruct them not to come to the door or make sudden movements. Furtive behavior inside can be misinterpreted as hiding evidence. Finally, know the legal exceptions at a high-level consent. A valid search warrant, a valid arrest warrant, or exigent circumstances and immediate emergency can lawfully justify entry. But those are specific and narrow. Your job during the encounter is not to litigate the law on the porch. It's to preserve your rights, refuse consent, request to see a warrant if claimed, remain silent, and avoid actions that give rise to probable cause. If you believe your rights were violated, write down everything as soon as you can and consult a lawyer. That's where the battle belongs. When an officer or ATF agent shows up, one of the first traps is confusion over what kind of firearm you own. The law divides firearms into 2 big categories. Non-NFA firearms are what most people have: handguns, shotguns with standard barrels, rifles like an AR-15 or bolt action, common sporting arms. These are regulated, but they don't fall under the strict National Firearms Act. NFA firearms are different. This group includes machine guns, short-barreled rifles or shotguns, silencers or suppressors, and destructive devices. Owning one legally requires paperwork and tax stamps filed with ATF. That paperwork is usually a Form 1 or a Form 4. Here's the key. Even if you legally own an NFA firearm and you filed a Form 1 or Form 4, you did not sign away your Fourth Amendment rights. Some people think, well, because I registered this item with ATF, they can just come in any time to inspect it. That is not true. The forms are not a back door into your home. They document the registration and transfer. They do not give ATF standing permission to enter without a warrant. If an agent shows up and says, "Because you filed a Form 1, we need to come inside and inspect your suppressor," your response is the same as with any other firearm: I do not consent to any search. If you have a valid warrant, please show it. Nothing in the paperwork changes that script. Now, there are federal firearms licensees, dealers, manufacturers, importers, who do agree to inspections of their licensed premises, but that's business property under a license, not your private home. If you're just a private owner with registered NFA items, the ATF has no greater right to enter your home than for non-NFA firearms. The danger is that many gun owners don't know this, and agents sometimes lean on that ignorance. They may say, "Well, you signed the form, so you agreed to inspections." No, the form authorizes possession, not unlimited searches. Hold your ground, keep the door closed, and return to the safe script "no consent." Warrant only. This distinction matters because it strips away one of the strongest pressure tactics convincing you that your NFA paperwork equals an open invitation. Once you understand that's false, the encounter at your door becomes simpler. If they lack a warrant or a true emergency, they leave, and you stay in control. You're on the road, maybe a little over the limit, maybe a taillight's out. Suddenly, flashing lights in your mirror. You pull over. Right there, the stop is a seizure under the Fourth Amendment. You are not free to leave. What happens in the next minutes decides everything. Before the officer even reaches you, engine off, both hands on the wheel, interior light on if it's dark. Stay still. No sudden movements. This tells the officer you're safe and controlled. When they arrive, keep it simple. "Good evening, officer. Here's my license and insurance." Nothing more. No excuses. No explanations. Small talk is a trap. It's how routine stops turn into full searches. This calm, direct start lowers tension, protects your rights, and keeps you in control. From here, everything you do should reinforce that same steady tone. Stay seated unless instructed otherwise. Let the officer lead the interaction, but do not volunteer anything beyond what the law requires. If they ask for your registration, tell them exactly what you are about to do before you move. "I am going to open my glove box to get it." That simple narration eliminates ambiguity and prevents claims that you were hiding or reaching for something. Keep your answers short and neutral. If asked where you are headed, you are not required to provide a story. If asked why you were driving a certain way, do not admit guilt or offer excuses. A polite "I'd prefer not to" answer is enough. The goal is to avoid handing over statements that could be twisted into probable cause or used later in court. Control the stop with discipline. Move only when asked. Narrate what you're doing, and speak only as much as necessary. That discipline protects you just as much as the law does. Officers are trained to use questions that sound casual, but are designed to make you slip. "Do you know why I stopped you? Have you had anything to drink tonight? Do you have anything illegal in the car?" These are not harmless. They are invitations to incriminate yourself. If you answer, even politely, you've given them material they can twist into suspicion. You don't need to play along. The safest move is to refuse the trap with calm, respectful words. When asked if you know why you were stopped, the answer is simple: "No, officer." That's it. Don't guess. Don't admit. Don't explain. If they press about alcohol, drugs, or weapons, you don't argue or justify. You say, "I respectfully decline to answer." Then you stop. Silence here is not weakness. It's strength. Anything you say can be recorded, written into the report, and brought up in court. If you think a short comment will make the officer let you go, you are wrong. What it actually does is open doors you should be keeping closed. Officers may also phrase things in ways that blur the line between a question and a command. "You don't mind if I take a quick look in your car, right?" That wording is deliberate. If you hesitate, if you mumble, if you stay silent, They may treat it as consent. The only safe response is clear and firm, officer. I do not consent to any searches of my vehicle. Deliver it once, in a steady voice. Then stop. Do not fill the silence. This is the key to surviving the verbal side of a traffic stop. You are not there to debate. You are not there to tell your life story. You are there to comply with the law. License, registration, insurance, and nothing more. Every extra word is a potential risk. If the officer tells you to step out of the car, you must comply. The law allows them to give that order, but compliance does not mean consent. Move slowly, keep your palms visible, and step out calmly. As you do, say, I am not resisting. I do not consent to any search. That short statement protects you while showing you are cooperative. Once outside, stand still and neutral. No hands in pockets, no pacing, no sudden movements. The goal is simple. Obey the command without giving away your rights. If the officer decides to frisk you, remember what the law allows. A pat-down is only for weapons, not a full search of your pockets or belongings. But in the moment, arguing about scope won't help. The best way to protect yourself is to cooperate physically while refusing consent verbally. Stand still, keep your hands visible, and let the officer do what they're going to do. At the same time, say clearly, I do not consent to this search. Repeat it if you need to, but don't resist. Resistance on the roadside only makes things worse. The words are what matter, because they preserve your rights later. Do not answer questions during the frisk. Do not explain what's in your pocket. Do not joke about it. Do not volunteer information. If something is discovered, let your lawyer address it in court. Your job is to stay safe, keep calm, and make sure the record shows you never agreed to be searched. When the stop shifts from questions to a direct request to search your car, the stakes change. This is no longer casual conversation. If you agree, even with a nod or silence, the search becomes lawful, and everything found inside can be used against you. Courts have ruled that hesitation, shrugging, or failing to object may be treated as consent. That is why your answer must be unmistakable. Look the officer in the eye and state clearly, Officer, I do not consent to any search of my vehicle. Say it once, firmly, and then stop talking. Do not soften it. Do not add excuses. Do not argue. That single line protects your rights more than any explanation ever could. If the stop drags on and you are left waiting without clear action, you need to force clarity. The safest move is to ask one controlled question. Am I free to leave? If the officer says yes, drive away calmly. If the answer is no, the stop has become detention. At that point, stop talking and say, I invoke my right to counsel. From then on, give no explanations, no stories, no excuses. Every word beyond that only creates risk. The moment you assert your right to a lawyer, the responsibility shifts off you and onto the system. Looking back at both scenarios, the formula is simple. At home, never open the door without a warrant. On the road, never let casual talk become a confession. In every situation, remember the three pillars: do not consent, stay silent, and demand to see the legal authority before you comply. Those short moves protect your Fourth and Fifth Amendment rights more than any clever argument or long explanation ever could. The key is consistency. Repeat the same safe phrases every time. I do not consent. I invoke my right to remain silent. Am I free to leave? These lines are your shield. Learn them, use them, and stick to them. In the end, your best defense is calm discipline. Do not fight battles on the doorstep or the roadside. Preserve your rights, speak the protective phrases, and let the courtroom be the place for arguments. Stand firm, stay silent, refuse consent, and you walk away with both your safety and your freedom intact.